When Chris Kalitza recognizes that Nadler's citation for contempt against the sitting Attorney General William Barr is not worth the paper it's written on, you know we have entered a realm when politicians are going to do what politicians do best.
And that is politic.
If that's not already a known term, I'm making it up right now.
Politicians gonna politic.
For those of you who don't know me, I am Viva Frei, a Montreal litigator turned YouTuber. I do these things called vlogs, VLAWGS, trademark pending in Canada and the US, in which I break down something that's going on in the legal world in terms that can be understood by lawyers and non-lawyers alike. A popular request that I can no longer in good conscience ignore is breaking down Bill Barr's citation for contempt that was issued against him by the House Judiciary Committee and Nadler a couple of weeks ago. Now, this has proven very difficult a topic for me to break down, on the one hand because I don't want to be accused of political bias, because I don't have any, because I am perfectly politically objective. That said, I know darn well that no matter what I say or how I say it, I am going to be accused of political bias by both sides of the aisle. So I'm going to live with that. The other thing that has proven tremendously difficult in breaking this down is that I am both Canadian and... wait, what's the other one? I'm Canadian. I am not totally well versed in the American governmental system and how it works, so breaking this down I have actually learned a lot. The other thing that I learned that's very important is that Bill Barr is not the same person as Bill Burr. That's a joke. Okay, so starting from the beginning, how do we break this down? You need to understand the three branches of the American government. There are three branches of the American government. You have the congressional, the executive, and the judiciary. That's right. And the oversimplified American government for idiots breakdown of this is that Congress makes laws, the executive branch enforces law. Yes?
Did you bring my bike in?
I did not bring your bike in. It should be by the tree. Tell Mom to text me if your bike is no longer by the tree. Sorry?
It's there.
Okay. The congressional branch makes laws, the executive branch enforces laws, and the judicial branch interprets laws. And so in the grand context of the American government, Congress has what they call congressional oversight over the executive branch. And so the congressional oversight pertains to overseeing how the executive branch enforces and implements and carries out the laws that have been passed by Congress. And if there's disagreement over that, then you have the judicial branch, which interprets laws and determines how they are to apply. Congressional oversight is sort of an inherent constitutional power of Congress that goes all the way back to 1790. It sort of guarantees certain checks and balances within the three branches of government. And included in the inherent powers of congressional oversight is the power to issue congressional subpoenas. Now, for those of you who don't know what a subpoena is, typically it is an order of the court forcing someone to appear as a witness. Witnesses for trials, witnesses for depositions get served with subpoenas. It is officially an order of the court requiring a person to show up, to be examined, to be deposed, or to be called on as a witness. Congress, so as to ensure that the executive branch is carrying out their functions properly, has the power to issue congressional subpoenas, compelling people to appear as witnesses and compelling them to bring documents. At the very least in Quebec, and I suspect it's the same elsewhere, you have what is called a subpoena duces tecum, which is a subpoena not only compelling someone to appear as a witness, but to bring with them certain documents. And so Congress has the inherent power to issue congressional subpoenas, forcing witnesses to come and forcing witnesses to produce documentation that is required for the congressional oversight for whatever the issue it is that they are looking into. And so this is what the congressional oversight has done. They have issued a subpoena to William Barr, Bill Barr, to both testify on the Mueller report, and they ordered him to produce an unredacted version of Mueller's report, which was dealing with alleged Russia collusion with the Trump campaign for the purposes of influencing the American election. Now, for those of you who don't know, Bill Barr authorized the release of a redacted version of Mueller's memo. I actually did a breakdown of the full Mueller report. I'll link it right here. Check it out, it's a good video if I do say so myself. The congressional subpoena ordered Bill Barr to produce the full unredacted version of Mueller's report. Why was the report redacted in the first place? There are certain things that need to remain confidential, even in the version of Mueller's report that was released to the public. There were 4 categories, including techniques, ongoing investigations, and grand jury testimony. So the congressional subpoena ordered Bill Barr to produce the unredacted version of Mueller's memo. Bill Barr refused on the basis that he cannot so disclose the unredacted version because it would violate certain rules of confidentiality. We'll get into those. And as a result of his failure to comply with the congressional subpoena, Nadler and the House Judiciary Committee voted to hold Bill Barr in contempt of Congress for refusal to comply with the congressional subpoena. That is the overall landscape. Now, as a lawyer, I know that in the judicial system, if a witness or a party receives a subpoena, they, alone or through counsel, can seek to have that subpoena quashed, cancelled, annulled, basically meaning that they no longer have to appear as a witness or they no longer have to produce the documents that were ordered in that subpoena. So my first reaction is, why can't Bill Barr just make a motion to quash the congressional subpoena. I quickly learned that there is a judgment declaring that congressional subpoenas cannot be quashed by the courts because the courts do not interfere with congressional oversight. So basically, once the congressional subpoena is served, there is no way of canceling or quashing that subpoena. The courts do not intervene in what is regarded as a political measure. So Bill Barr gets served with a subpoena, he has to appear as a witness, and he has to produce the required documentation under penalty of being held in contempt of Congress. Now, another interesting thing that I discovered while researching this is that while Congress has the inherent powers to issue congressional subpoenas in the context of congressional oversight, they do not have the power to conduct investigations on their own. That is to say that the congressional oversight that Congress might exercise has to be related to the functions of Congress. It is not a rogue investigative committee that can use its congressional powers to investigate individuals. And so congressional oversight relates to how the executive branch is carrying out its functions as relates to legislative matters, congressional matters, etc. One thing I don't understand, and it might be because I'm too simple in the matter, I don't know to what legislative matter the congressional oversight that Congress is exercising now relates. I know it relates to disclosing the full unredacted version of the Mueller report, but I don't fully understand how that relates to a congressional matter that Congress has oversight over. I'm just going to have to operate on the basis that Congress does actually have the requisite authority to exercise its oversight as relates to the release of the unredacted Mueller report. Regardless, they've issued the subpoena. Barr has not complied with it because he has neglected or failed or refused to provide the unredacted Mueller report. Why? Because he says he can't provide the full unredacted Mueller report because it would violate certain rules of confidentiality.
What are those rules of confidentiality?
Well, it seems that according to the federal rules of criminal procedure, certain matters relating to grand jury testimony and evidence has to be kept secret or confidential.
Period.
And because politics is one heck of a dirty game, what is actually going on is that the House Judiciary Committee issued a subpoena ordering Bill Barr to produce documents that he cannot legally produce. And if we're looking at this entirely objectively, it's not as though Bill Barr has refused to produce any portion of the Mueller report. For anyone who watched my previous video, you'll know that 90% of the Mueller report was unredacted. Certain elements were redacted and kept confidential for various reasons, one of which relates to the fact that grand jury testimony has to remain confidential and secret in accordance with the federal rules of criminal procedure. So Bill Barr could not legally comply with that subpoena, and I presume a lot of people knew it and that it was a political move to begin with. Now, Bill Barr is not the first Attorney General to be held in contempt of Congress. Eric Holder was held in contempt of Congress in 2012. And for those who are not familiar with that situation, we'll get into it a little bit only to distinguish what makes it somewhat different than the current situation with Bill Barr. Eric Holder was held in contempt of Congress in the context of something called the Fast and the Furious, for those of you who don't know what that is. It's also known as gun walking or letting guns walk, and it was basically a tactic being used by the ATF, the Alcohol, Tobacco, and Firearms Department, whereby they were actually illegally and knowingly allowing the purchase of firearms so that they could track the firearms to Mexican drug cartels. The program was going on for years, and what ended up happening was that a border agent got killed by a gun that was sold through this program. And the scandal came to light, and in the context of that scandal, Attorney General Eric Holder was subpoenaed to testify on his knowledge of the program and to communicate documents pertaining to the implementation and running of that program. What ended up happening is that Eric Holder provided testimony confirming that he only became aware of the operation Fast and the Furious at a certain date, but documentation that was subsequently provided under the subpoena confirmed that Eric Holder was in fact aware of the program well before the date that he told to Congress. So there are some material differences between why Eric Holder was held in contempt of Congress versus William Barr. At the very least, in the situation where Eric Holder was held in contempt of Congress, it related specifically to a program that was being implemented by the ATF. Regardless, we'll close that parenthesis, all that to say that this is not the first time an Attorney General has been held in contempt of Congress. There may or may not be material differences between Eric Holder's situation and Bill Barr's situation. I happen to think there are differences in my limited understanding of the situation, but that'll be for you to do further research and come to your own conclusions on. And what's going to happen now? The same thing that actually happened in Eric Holder's contempt of Congress situation. We're going to go into something called executive privilege. And what is executive privilege? The oversimplified executive privilege for dummies? It's the power of the president or the executive branch to refuse to comply with subpoenas on the basis that it would interfere with their ability to govern. It would interfere with their governmental functions, or it would not be in the best interest of the general public to release that information. Executive privilege is the power of the President of the United States or other members of the executive branch to refuse to comply with subpoenas on a number of bases. Obama exercised executive privilege with respect to Eric Holder as relates to the release of certain documents, and right now President Trump is exercising executive privilege privilege as relates to releasing the full unredacted Mueller report by Bill Barr. And that is the breakdown of the Bill Barr contempt of Congress situation. The obvious questions that people should be asking themselves is this just political theater? As relates to what was released of the Mueller report, is it contemptuous not to release the full unredacted version compared to the redacted version that was in fact released? I read through the entire Mueller report. I can appreciate and understand the things that were redacted in it. It's not as though the redactions make that document useless. I have seen redacted documents where the entire page is black, save and except for a few words. The redacted Mueller report can pretty much be read beginning to end and fully understood. It's quite clear what is being redacted. It's quite clear why it was being redacted because it was color-coded and indicated. And it is a known rule that grand jury testimony has to remain confidential. So the question people have to be asking themselves are, in issuing a subpoena that you know by law someone is going to have to refuse, is it political theater for the purposes of creating an alleged or apparent contempt of Congress? That is going to be a question for you to answer. Let me know in the comments below what you think. And as always, like, share, subscribe, hit the notification bell, tell your friends and family about my channel. Help me grow. I greatly appreciate it. And now you know your vlog. Peace out. Boom!